must make its decision. These rules are different from other types of land use decisions like rezoning cases. The board's discretion is limited. The board must base its decision upon competent, relevant, and substantial evidence in the record. A quasi-judicial decision is not a popularity contest. It is a decision constrained by the standards in the ordinance and based on the facts presented. If you will be speaking as a witness, please focus on the facts and the ordinance standards, not personal preference or opinion. Parties with standing have rights to participate fully. Parties may present evidence, call witnesses, and make legal arguments. Parties are limited to the applicant, the city, and individuals who can show they will suffer special damages. Other individuals may provide testimony as witnesses when recognized by the board. Witnesses must swear or affirm their testimony. Any individual wishing to speak as a witness today was required to sign up. If you haven't done so, please do so now. General witness testimony is limited to facts, not opinions. For certain topics, this board needs to hear opinion testimony from expert witnesses. These topics include projections about impacts on property values and projections about impacts of increased traffic. Individuals providing expert opinion must be qualified as experts and provide the factual evidence upon which they base their expert opinion. While hearsay evidence is not specifically excluded, it is only giving limited weight. The parties to each case are entitled to impartial decision making. A board member may not participate in a hearing if she or he has a fixed opinion about the matter, a financial interest in the outcome of the matter, or a close familial business or associational relationship with an affected person. The parties to each case also have a right for any ex parte communication to be disclosed. Ex parte communication is a communication about the case outside of the hearing. That may include site visits as well as conversations with parties or the general public. At the start of each case, any potential conflict of interest or ex parte communication should be disclosed by a board member. If applicable, these matters may also be raised by any affected party. Today's meeting will follow the order printed on the agenda. The board will hear one type of cases, applications for a variance for the regulations in the zoning ordinance or UDO. The recommendation agenda would be as follows. The zoning administrator or zoning staff will identify the case and recommend approval of the variance with any recommended conditions based on specific reasons. The chairperson will ask if anyone wants to speak in opposition. If there is such a person, then the case will be moved to the regular agenda and will be heard at a later time. After staff's presentation, the chairperson will ask if the board has questions for staff or if there is any reason the board wishes to move the case to the regular agenda. If a board member has concerns about approving the variance, the member should request to move the case to the regular agenda so the applicant may have an opportunity to present its full case and answer any board member's questions. The chairperson calls for a motion and a second to approve the variance. The chairperson will hold a roll call vote. The order of the regular agenda will be as follows. All parties who plan to give testimony must be sworn in. A zoning staff member will present a summary of the variance request or the decision being appealed. The board may question the staff member and then the applicant may question the staff member. The applicant presents their testimony for the case. The board may question the applicant and the zoning staff may also question the applicant. The applicant may present other sworn witnesses. They will also be subject to questioning by the board and staff. Other parties wishing to speak for or against an application will be given reasonable time to present sworn testimony. The staff and then the applicant will be given an opportunity for rebuttal. After hearing each case, the board will review each case and render a decision. This is usually done in closed deliberations after hearing each case. The chairperson calls for a motion and a second to approve or deny the variance. In the case of an appeal, the chairperson calls for a motion and a second to uphold, modify, or reverse the administrator's decision. The decision will be made by a simple majority vote of the board. However, the board may elect to take up to 30 days to render a decision. You may remain present during the deliberations, or you may call the zoning staff after the session to receive the decision of the board. All exhibits must remain with the board. If your case is not appealed to Superior Court after 30 days, you may pick them up or they will be destroyed. Appeal from this board is to the Mecklenburg County Superior Court. You have 30 days from the date of the board's written decision in which to appeal in accordance to North Carolina General Statute 160D-405D. In a order to receive a written copy of the decision, any aggrieved party must file a written request for a copy of the board's decision by filling out the form, which must be filed with the board's clerk or chairperson at the time of the hearing of the case. We will hear 3 cases today. The first case that we will hear is case number, just kind of going in reverse order here, is case number 2022-007. I know, where's Mr. Murray? There he is. I received notification from staff that you wish to do a continuance.
Yes, members of the board, since this is a contested variance, I'd request an extension to next month
Okay,
so that we can have 5 board members.
all right,
Thank you.
great. And I just had a morning blank. Jill, do we have to vote on the continuance? Or, okay, we do. All right. Okay, great. Is there a motion on the floor to continue case number 2022-077? You said to September? Or is it certain?
Yes, to the September calendar.
September.
I make a motion to approve the continuance of this case.
Motion's been moved and seconded by, the motion been moved by Ms. Dryden and seconded by John Floyd. Now we move into a roll call vote. Mr. Floyd?
Yes.
Ms. Dryden?
Dryden, yes.
Mr. Court?
Yes.
Wilson, yes. Okay. Thanks a lot. Now, our next case, I just want to inform the applicant as they come up.
I think the first one
Yeah,
has to move as a matter of,
has to be moved. Okay. All right. So we're gonna be moving that to September as well.
Yeah.
Yeah.
Mr. Chairman, due to the potential conflict of interest that one of the board members has as it pertains to this case, they would have to recuse themselves and it would take the number of members down to 3, which would be under quorum. So you
Okay.
wouldn't even be able to vote on the continuance. As such, it would be best to just ask the zoning staff to move the case to the next
Okay,
available agenda.
okay. All right, so staff, if this can be moved to whenever, if it's September or any month in the future, go from there. Okay. Sam, you got a question? Okay, okay. Oh, I got you. Okay. So that will mean our next case would be case number 2023-058. And while everyone's coming, Terry, do we have anybody in opposition to this case?
No, Chair, no
Okay.
opposition. No opposition.
All right, okay, all right. And Lisa, let me swear you in. I should know this thing by heart. I'm just gonna go off my head. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth in the matter at hand? I think. Okay. And Terry, did you pass around this information for this case?
This is a
Mr.
rear
Chairman.
setback variance, and I'll give you a minute to look at your agendas or
Okay.
your findings.
Thanks, man.
Mr. Chairman.
And I'm gonna swear you in case we have questions for the applicant. If you can, if you want to place your hand on, if you feel comfortable, place your hand on the Bible. Yeah, raise your right hand. First, for the court reporter, can you please state your name and address?
Mr. Chairman,
Oh, he
Just
can't.
before we move forward, if the board, after the presentation, decides to remove the case from the consent agenda, given the number of board members, if you could please extend an opportunity to the applicant in case they do want to continue the case to the next agenda. But that would be a decision that you'd make if you do want to remove the case from the consent agenda.
Are you just talking about going forward or just for in reference to today?
Moving forward, if the
Okay.
board decides to hear the case outside of consent.
Gotcha. Okay. All right. All right. Yeah.
Do you want the address and the case number?
Just sit there.
Just sit it for a while. Yeah, yeah. Okay. And you usually give your name already?
Well, we don't really need to have his name yet because if we leave it on the consent agenda,
I got
we
you.
don't need to ask him any questions. We just
Okay.
take recommendation from staff.
Okay. All right. All right. But he says to be sworn in, right? If you okay. I just want to make sure. All right. Okay. All right. Okay, you may proceed, Lisa. Sorry about that. Sorry for the confusion.
Exhibit number 1 is a vicinity map of the property. Exhibit number 2 is a zoning map. The property is zoned N1B, and this is reviewed under the UDO standards. Exhibit number 3 is an aerial map. Property is a corner lot. Exhibit number 4 is a close-up aerial map. According to the setback definitions in the UDO, the front is the narrower side along Sudbury, and then the longer side is the corner side setback. So this is the rear yard. Exhibit number 5 is background. The property was subdivided in 1965, and the home on the property was also constructed in 1965. Exhibit number 6 is the variance request. The required rear yard in N1B is 35 feet. The home on the property has an established rear yard of 8 feet. The applicant would like to place an addition on the rear of the home that aligns with the established rear building line, and they're asking for a 27-foot variance for the addition. So this is the area of the addition in the hatched area that encroaches into the rear yard. Exhibit number 7 is the variance criteria, and all must be met. That unnecessary hardship results from strict application of the ordinance. The hardship results from conditions peculiar to the property. The hardship did not result from actions taken by the applicant. The requested variance is consistent with the spirit, purpose, intent of the regulation, and public safety is secured. Exhibit number 8 is considerations. Staff supports the requested variance. Strict application of the ordinance would prevent the proposed addition since there's no permitted building area on the rear of the home. There are property conditions that contribute to the hardship. There's a power line easement that runs through the center of the property, so you can see it right here. And it prevents placement of the addition on the front of the home. North Sharon Amity is an arterial road, so there's a 27-foot corner side setback instead of the standard 13.5 feet for local and collector roads. And the existing home abuts that 27-foot corner side setback. It actually goes into it a little bit. So there's no allowed building area on that side. Due to the location of the power line, the established front setback is 72 feet, and that's 42 foot greater than the required 30-foot setback per the subdivision plat, and that decreases the building area to the rear of the home. Exhibit number 9 is considerations. The home was constructed in 1965, and the applicants purchased the property in 2020. The requested rear setback of 8 feet doesn't exceed the established rear setback. The applicant states this will allow the addition to align with the existing home. The variance will not cause any safety issues. And exhibit number 10 is some photos. So here's the view from the front on Sudbury and also another Sudbury. And this is the view from North Sharon Amity. So the rear would be right back here. And that's the end of my presentation. If you have any questions for me.
Does anybody have questions for staff? Any questions for the applicant?
We can't ask him any questions.
I know.
It's on the consent agenda.
Yeah, that's right. That's right.
It's just Unless we disagree with the recommendation. of
Okay, got it.
Staff.
Just try to get used to this thing.
I don't have any questions.
Any questions?
Question, all right.
Then I make a motion to approve this variance based on the difficulties of this person, the uniqueness of the topography and the plot and the power lines.
Second.
Is there a second? Okay. Motion's been made to approve the variance by Ms. Dryden and seconded by Mr. Floyd. All right, moving to a roll call vote. Mr. Floyd,
Wood, yes.
Ms. Dryden,
Dryden, yes.
Mr. Court,
Court, yes.
okay, Wilson, yes. Due to finding facts and conclusions of law.
Yeah, I just have one change, small typo, I think paragraph 11, per article 38.3D. It should either read a non-conforming structure or non-conforming structures. That's it.
So take out the A.
Yeah.
All right. Get that. Yeah.
Motion to approve the findings of fact and conclusions of law as amended.
Okay, is there a second?
Second.
A motion was made by Mr. Floyd to approve the finding facts and conclusions of law as edited, second by Mr. Court. Now move to roll call vote. Mr. Court,
Court, yes.
Ms. Dryden,
Dryden, yes.
Mr. Floyd,
Wood, yes.
okay, Wilson, yes. Okay, so this case is completed. Is there anything else that I'm missing before I go to approving the minutes? Okay. All right, so last thing on the agenda is the approval of the July minutes. And Terry handed that out earlier. Just look at that. Is there a motion to approve the July minutes as written?
Move to approve.
Motion was moved to approve the July minutes by Mr. Court. Is there a second?
Dryden, second.
Second by Ms. Dryden. Now we're moving to a roll call vote. Mr. Floyd, Ms. Dryden,
Dryden, yes.
Mr. Court,
Court, yes.
okay, Wilson, yes. Okay. Staff, is there anything else that needs to be discussed or? Okay. Anything else? Okay. All right, hearing none, is there a motion to adjourn the meeting?
Move to adjourn.
Second.
All right, motion was moved to adjourn by Mr. Court, second by Ms. Dryden. Now we're moving to roll call vote. Mr. Floyd?
Wood, yes.
All right, Mr. Court?
Court, yes.
All right, Ms. Dryden?
Dryden, yes.
Wilson, yes. All right, meeting is adjourned.